So those benefits might include an adjusted and competitive cost structure adapted to local or regional practice. They might include building capacity of lawyers with local knowledge who are familiar with the legal culture in the jurisdiction or region and who are well versed in the local law and the languages that will need to be used in the arbitrations. Regional hubs also offer the potential to provide specialized dispute resolution mechanisms that are adapted to suit the particular kinds of disputes that may arise in a region, or adapted to reflect legal practices that lawyers expect to encounter in their dispute resolution processes. A few examples. Think of South Africa's Commission for Conciliation, Mediation and Arbitration, which is a statutory body designated with the powers to hear workplace and labor disputes in a context where labor disputes are extremely dynamic, fast-moving, and you need a variety of dispute resolution mechanisms in the toolbox to resolve those effectively. Think of India's Construction Industry Council, established to resolve construction and infrastructure disputes, and very focused on the kinds of processes that emerge there. Think of institutes that have produced rules tailored to complex financial disputes, such as HKIC's securities arbitration rules and SIAC's derivative trading and clearing rules. And think of the China-Africa Joint Arbitration Centers, KJAC, in Southern and East Africa, established to create a forum for the resolution of international disputes between Chinese parties and African parties, given the multiplicity of trade agreements between those two regions and the expectation that those trade agreements will inevitably lead to later disputes. Other specialized mechanisms can reflect important elements of local legal culture. And here, Dutch arbitration practice gives a couple of interesting examples. The first is the availability of standalone summary arbitral proceedings, popularized by the local arbitration institute, the Netherlands Arbitration Institute, and later incorporated into the Dutch arbitration legislation. A second example in the Netherlands is the availability of binding third-party rulings, a practice which is akin to arbitration, used in situations where arbitration may not be available and enforceable through contract. What makes these procedures interesting is that they are derived from or inspired by local court practice, and they meet a need for quick and pragmatic mechanisms that Dutch litigation lawyers are accustomed to having in their toolkits, and they expect also to have in arbitration. A couple more examples. In Sweden, think of the Stockholm Chamber of Commerce's pioneering of expedited disputes, expedited procedures for disputes, and its newest innovation, the express dispute assessment. In Hong Kong, think of the Financial Dispute Resolution Center, requiring parties to first mediate before they move on to arbitration, reflecting the increased emphasis on the use of ADR procedures that was quite an early feature of dispute resolution practice in that region. So newer arbitral hubs can clearly offer specialized solutions that meet the expectations of local users or are responsive to issues or legal culture peculiar to that region or jurisdiction. A celebration of the positive potential of diversity, if you will. But of course, emerging hubs also face a set of unique challenges. For the jurisdiction itself, reputation building is key. Building a solid reputation as a reliable or safe seat requires action on multiple fronts. The first essential element, as I think we can all agree, is a solid and modern arbitration legislation. So in Saudi Arabia, the 2012 and 2017 arbitration regulations and implementing rules bring the Saudi arbitral framework very close to the model law system, the UNSTRL model law system, which is a very welcome development. We've seen similar developments in sub-Saharan Africa with 11 jurisdictions that are now model law countries and a further 17 OHADA jurisdictions that are part of an OHADA-based system that is largely model law compliant. And I feel confident in saying that it's those jurisdictions that have conformed their local arbitral frameworks to the model law that have done best in terms of building international reputations. The second essential element of reputation building is courts. Courts who are willing to support but not interfere during the course of the arbitral proceedings. The third element is consistent enforcement of arbitral awards under the New York Convention and other relevant enforcement treaties. And here, it's not enough for courts to be acting reliably. They also need to be seen to be acting reliably. So transparency is very important. Commercial parties simply won't risk seating their arbitrations in jurisdictions that are largely unknown and unproven unless they are absolutely certain that they know in advance how the courts are deciding arbitration-related court applications and developing the confidence that those applications are being decided consistently and in accordance with good international practice. So based on the SCCA's very interesting recent 3-year survey of court decisions in 1,400 domestic arbitrations, the Saudi Appeal Court's track record with respect to enforcement and annulment of local awards is excellent. It's critical that this be made widely known and that the decisions are available for all to scrutinize. I also encourage the SCCA, when you can draw breath, to conduct a similar survey focusing on the enforcement of foreign arbitral awards. That's also something that investing parties will be very interested in having a very clear idea of. Now, to build and consolidate this judicial track record, in particular with regard to the enforcement of foreign awards, there is a treasure trove of guidance in the form of practice guides for judges, such as ICCA's guide to the interpretation of the New York Convention, as well as comparative case law from other jurisdictions enforcing the New York Convention and similar conventions. Published, for instance, in ICCA's yearbook Commercial Arbitration, available in the Kluwer Arbitration database. To succeed in this area, national court judges need to develop a really internationalist attitude. As memorably said by the then Chief Justice of Mauritius at ICCA's first ever New York Convention Roadshow in 2012, the national judge cannot stay stuck in his national grooves. His judicial mind needs to become part of the transition to effective resolution of international disputes. A fourth element of reputation building is impeccable case management by arbitral institutes. Newer centres really can't afford blunders based on untransparent or inefficient case administration, or case administration that's not consistent with the expectation of users accustomed to more established centres. And finally, transparency is also key to developing confidence in the work of local decision makers, the arbitrators, which is why publication of arbitral awards is so important. Here, ICCA, through the large established and curated Kluwer arbitration database, as well as Jusmundi, ICSID, and UNCTAD, offer good platforms for the publication of arbitral awards, with ICCA actively growing its existing database of published anonymized awards in commercial cases, totaling already 700 anonymized awards and available through a new dedicated ICCA awards series launched in 2023, also available on Kluwer arbitration. Now, the new institutes themselves also face challenges. For instance, institutes need to critically develop their focus and their purpose. Who are the key users going to be? Which categories of disputes will they focus on? Who can be relied on to support the centre? A good example of a successful approach to growing a caseload is the Kigali International Arbitration Centre, KIAC, which has developed a significant international caseload in quite a short period of time, around a decade or so, largely because of a commitment by the Rwandan government to insert references to KIAC arbitration in many government contracts. So the KSA's June 23 model agreement providing for SCCA arbitration in government tendering contracts, and the SCCA's November 23 MOU with the Saudi Minister of Foreign Affairs providing for the inclusion of SCCA's arbitration clauses in ministry-related contracts are thus very promising developments. It's a proven technique that works very well and could very well work in this context. Institutes also need to generate income, of course, to cover their running costs while caseloads are growing. They may need government support in the pioneering phase, which is somewhat controversial and has pros and cons. It offers the benefit of certainty, but the risk of perception of lack of full independence, and there may be a balancing act that needs to be followed. And of course, finally, everybody involved in an arbitration project, the government policymakers, the key arbitration specialists, the arbitral institutes, they all need to commit to capacity building of arbitrators, arbitration counsel, and case managers. How do they do this? For arbitrators, by building diverse lists of potential arbitrators, by offering arbitrator training, and by being transparent in appointment processes. More than that, institutes can also use the opportunity offered when called upon to make an arbitral appointment directly to entrust that appointment in appropriate cases to less tested, younger, and more diverse decision makers, particularly in low-value cases and for co-arbitrator appointments. This is good for the development of young arbitrators and arbitration expertise in the region. It's also a service to the international arbitration community because over time it grows the worldwide pool of potential arbitrators. Capacity building for arbitration counsel can be done by offering continuing legal education to qualified attorneys on the conduct of arbitral proceedings, on effective advocacy, on process management. It can be done through providing practical skills training for younger practitioners and by providing some coaching and some guidance, including from the Administering Institute for first-time users in an arbitral proceeding. And it can be done for case managers by, first of all, good training and then exposing them to a stream of live cases. Effective and sustainable capacity building requires patience and the willingness to adopt a potentially long-term horizon, because it involves a commitment to building that capacity and building those skills throughout the lifespan of a lawyer, from teaching at university level, through early skills training, to guidance through first-time or early exposure to arbitral processes. This latter role is often done very well by some of the established arbitral institutes, with legal staff available to provide guidance to the parties and their attorneys on procedure, good practice, and effective case management. And that's something that I imagine that the ICCA will also be doing in the future. So even with all these building blocks in place, perhaps the most useful quality required of institution builders is patience and a long-term vision. Now, ambition and vision are, of course, no strangers to this particular jurisdiction, which itself promises great things for the arbitration project. We're watching developments in this part of the world with excitement and interest. Thank you for this opportunity.